In the studios today, if you were listening to our last segment, you would know we've got Melissa Delana gracing us with her presence from Delana Law out of East Greenwich, Rhode Island, serving all of Rhode Island, and you guys probably do some out in Mass too, right?
As well, yes.
And Massachusetts as well, specifically to real estate. And Melissa's got a really wonderful topic today. And it's something that keeps coming up.
Yes.
Even agents fumble this thing all the time.
We are talking about the purchase and sales agreement and how that is a binding agreement between the parties.
Mm-hmm.
And what Emilio and I were talking about offline is that it seems as though in Rhode Island there's not a lot of attorney involvement at the time of the drafting of the sales agreement or the execution of the sales agreement. So the parties are going into this oftentimes without any attorney review. And I think in part they feel as though it doesn't have the same degree of seriousness because there's no attorneys involved. But make no mistake about it, a purchase and sales agreement is a legally binding contract between the parties.
Mm-hmm. And you know what? They've been written by attorneys. I mean, unless you're signing some purchase and sales agreement on a napkin or something that the agent designed. But
right. Well, hopefully our agents know better than to design sales agreements on napkins. The Rhode Island Forms Committee has done a very good job of giving us some standardized forms so that agents can pre-populate the information more easily without the need for attorneys. But especially in today's transaction, there's more and more complexities where there is language that needs to be drafted and added to the sales agreement.
Mm-hmm.
And oftentimes an attorney involvement is necessary at a much earlier point than when we're getting involved. So I guess the moral of the story is whether you're a buyer or you're a seller, you're going to need to have an attorney involved at some point in the transaction. You might as well get us involved early so that we are there to advocate for you and to review those terms and provisions so that you have a strong understanding as to what your rights and responsibilities are under the terms of the agreement. Yeah,
I would totally agree with you there. You're going to be paying this attorney anyways if you're a buyer or a seller, so you might as well go ahead and have them review these documents and get your money worth. Not that that they don't get their money worth later on because the transaction just doesn't finalize without title and closing attorneys and all that. But I would totally do that. I mean, when I was buying my house, I had my one of my attorneys review all of the documents. And it was definitely a good thing because there was something that was missed on there. And again, I mean, I do this. I suggest this with all of my clients. Every situation, every transaction is different.
Oh, 100%. There's no two closings and transactions that are alike. So, and one of the easiest ways to do it, if clients are going to do nothing else and not hire an attorney, is to make sure that you have read through the agreement and that you understand it and that all of your questions have been answered before you sign.
Yeah.
Far too often we see clients signing agreements and then it's only after the fact where there's a contingency date missed, for example, that they say, well, whose responsibility was it to request an extension?
Mm-hmm.
So it's important to have a full-time agent who's very seasoned in the sales agreement to explain to the client what the rights and responsibilities are and to answer any questions that the client has about the provisions in the agreement.
Yeah, definitely. And you know what? We've got a huge agent listener base, and I'm speaking with you, with the agents right now, because I know you come across this all the time. I'm sure you can totally relate to this. You ever have those clients that are like, no, let's just, I'll just sign away. Mm-hmm. I actually, as easy as that is, I stop them and I say, no, please, let's look at this section for section because you may have some questions. And if you don't have questions, I want you to understand, the reality of this agreement. And your life is going to change as soon as you sign this.
Yeah.
And the buyer's life is going to change as soon as you sign this.
I think especially with the e-signature phenomenon where most of our clients are just clicking. They're not even taking a pen to paper and signing it. So they're not even really spending the time eyeballing the document. They're just going on the computer and clicking, saying, yes, I agree. But if they haven't stopped and reviewed the terms, they won't know, for example, that as a seller, you have to furnish an oil reading from your oil company in order to get reimbursed for the value of the oil that's in the tank. And that is one of the very basic provisions that the buyer will reimburse the seller for the value of the oil or fuels that exist on the property.
Yeah.
But as a seller, you have to furnish them with a receipt. It's not good enough to just take a picture of the gauge because far too often those gauges are broken. So we need to have the oil company come out out. So there's some preparedness that's required, and you can only be prepared if you understand what those rights and obligations are.
Absolutely. So things like the water meter reading, the oil reading, things like that, your agent, can do for you. There's some agents that'll teach you how to do it, and then there's some teams, like our team, the DiSpirito team, we go out and we do that stuff for our clients as part of the service. But no way, either way is not right nor wrong. Now, one thing that I want to bring up, and again, for any agents listening, I want you to definitely tune into this, because you may think one thing or the other, and I want to ask Melissa, okay, because I've already asked her. I know what the answer is, okay? But Melissa, the closing date, okay? I've had clients jump down my neck, and I totally empathize with them. I totally understand where they're coming from and how it can be upsetting when a closing date is extended.
Yes. And that's a great question, and a point that we have a lot is
that closing date, is that closing date exact?
No. The closing date in Rhode Island is basically considered a target date, and that can be a moving target, especially when the financial company for the buyer, because most of these transactions are subject to loans, is not ready. The reason that is the case in Rhode Island is because we do not have time is of the essence as a provision that pertains to the sales agreement date. So when the buyer is not ready, there's no time is of the essence. They just simply require or request an extension of time, and the seller usually gives it to them. It's either ready or it's not. So I understand the seller's plight of, well, you're not ready, too bad, I want to move on. But at the same time, oftentimes we're looking at a couple of days, maybe a week. We're not usually looking at extensive delays, but it does impact the planning of sellers, especially if they're moving on to buy something else, or if they have made moving arrangements, or if they're traveling. So I can understand as well why that target date is something that people want to have as a firm date, but that's just not the reality. It's not a firm date. It's a target date until we're very close to the actual closing. Yeah,
you bet. Well said. I actually use those words, quote for quote target date, because, and that's one of the things that we do, and a lot of really, really experienced agents are going to do when they're going over the purchase and sales agreement. They're going to go through that with their clients and say, this is not an exact date, it's a target date. Now, even the mortgage contingency date is not an exact date. It can be extended. The inspections date can be extended.
Exactly. And that's why it's so important to understand what those dates are as a buyer. You have to complete your inspections by law within 10 days of the signing of the sales agreement, exclusive of holidays and weekends. Well, if it's a busy market and inspectors cannot complete the inspections inside of that time frame, and we don't have enough time to request repairs, then it's incumbent on the buyer, ultimately, to request an extension to that contingency date. And same with the mortgage. If the mortgage commitment date is not going to be satisfied by the lender, we need to request an extension of time. So often, the clients just rely on their agents to make sure that those dates are going to be extended accordingly. But again, if you have an agent who's not involved, or for whatever reason the transaction has become estranged where you're not talking to your agent, because believe it or not, that does happen, again, really underscores the importance of making sure there's an attorney involved and that you're having open lines of communication to extend accordingly. Because otherwise, if you miss a contingency date, then basically you're operating under an agreement with no contingencies. You have to close or else.
Yeah, or else you're going to lose that deposit.
Correct. Rule of thumb is that the negotiations for those repairs have to be completed, and addendum should be signed supporting those negotiations within that 10-day period. However, the repairs only have to be done at closing, or if the lender will allow, then we can hold an escrow. But I just want to caution, you have to make sure you're keeping the lender informed, because they don't always allow for an escrow, depending on the type of financing, depending on the type of repair, and depending on the attorney. There's some attorneys out there that carte blanche will not hold escrows. It's just the way they operate.
So, and I know that you guys hold escrow.
Regrettably, yes.
Yeah,
we do hold escrows as required. They can often lead to problems. In my first year of practice, I was actually sued over an escrow because I would not release the money because the parties wouldn't agree. So then they had a lawsuit. I was dragged into the lawsuit. It just created a little bit of a nightmare. So escrows are not the ideal way to proceed. We always want to try to get the repairs done ahead of time if possible, but if necessary, escrows are an option as long as the lenders allow.
And escrow is a whole nother subject for a whole nother day. We actually got to run to a quick commercial break, but you can get a hold of Melissa DeLana for some really great real estate advice at 401-885 885-3800. She's one of the best in the state, and I personally recommend her. 401-885-3800. Contact Delana Law and ask for Melissa.